California has arguably the most extensive and tenant-protective habitability laws in the entire United States. If you own rental property in the Golden State, you are operating under a multi-layered regulatory system that leaves very little room for error. Understanding these laws isn't just good practice, it's essential to surviving as a California landlord. California's habitability framework starts with Civil Code Section 1941, which establishes that every residential landlord must put the property in a condition fit for human occupation and repair all subsequent dilapidations that render it unfit. This statute has been on the books since the 1800s, making California one of the earliest states to codify habitability requirements. Building on that foundation, Civil Code Section 1941.1 spells out specific conditions that make a dwelling unsubstantial, meaning uninhabitable. These include inadequate waterproofing and weather protection of roof and exterior walls, defective plumbing or gas facilities, lack of hot and cold running water or water connected to a sewage disposal system, defective heating facilities, lack of electricity or inadequate wiring, unsanitary building conditions including infestation of insects, vermin, or rodents, deteriorated flooring or stairways, lack of adequate trash receptacles, and lack of functioning deadbolt locks on main entry doors. But California didn't stop there. The state has continued to expand habitability requirements through additional legislation. Civil Code Section 1941.3 requires working window security bars with quick-release mechanisms. Health and Safety Code Section 13113.8 requires smoke detectors. Health and Safety Code Section 17926 mandates carbon monoxide detectors. And Assembly Bill 1482, the Tenant Protection Act, added statewide rent caps and just cause eviction requirements that interplay with habitability in important ways. On top of all that, California has the state housing law under Health and Safety Code Sections 17910 through 17998.3, which sets minimum construction and maintenance standards for all residential buildings. This law is enforced by local building departments and creates yet another layer of obligation for landlords. What makes California truly unique is the breadth of tenant remedies. California tenants have an arsenal of options when a landlord fails to maintain habitable conditions. They can use the repair and deduct remedy under Civil Code Section 1942. After giving the landlord reasonable notice, the tenant can make the repair themselves and deduct up to 1 month's rent. They can exercise rent withholding, which California courts have firmly upheld as a legitimate remedy for substantial habitability defects. They can abandon the premises under the doctrine of constructive eviction if conditions are severe. They can report violations to local code enforcement, which can inspect, cite, and fine the landlord. They can file a private lawsuit seeking damages for breach of the warranty of habitability. And they can raise habitability defects as a defense in any eviction proceeding. This is the famous Green v. Superior Court defense that has been used in countless California eviction cases. The Green v. Superior Court decision is worth understanding because it established that a tenant being sued for non-payment of rent can defend by showing that the landlord failed to maintain habitable conditions. If the court agrees, it can reduce or eliminate the rent owed for the period of the deficiency. This defense has made habitability compliance not just a maintenance issue, but a rent collection issue for California landlords. California's local jurisdictions add even more regulation. San Francisco has the rent ordinance, with its own inspection and enforcement mechanisms. Los Angeles has the Rent Stabilization Ordinance and the Systematic Code Enforcement Program, known as SCEP, which proactively inspects every rental unit in the city on a rotating basis. Oakland, Berkeley, Santa Monica, and dozens of other California cities have their own local housing regulations that go beyond state law. The Los Angeles SCEP program deserves special attention because it's one of the most aggressive, proactive inspection programs in the country. Rather than waiting for tenant complaints, SCEP inspectors systematically visit every rental property in the city on a regular cycle. Landlords are required to pay an annual fee to fund the program, and properties that fail inspection face escalating fines and enforcement actions. If you're a landlord in LA and your property isn't ready for a surprise inspection at any time, you have a problem. California's climate varies dramatically by region, which creates different maintenance priorities depending on where your property is located. Coastal properties deal with moisture and salt air corrosion. Properties in the Central Valley face extreme summer heat and air quality issues. Mountain and Northern California properties need robust heating and weatherproofing. And across the state, wildfire risk has become an increasingly relevant factor in property maintenance and safety compliance. California's anti-retaliation protections under Civil Code Section 1942.5 are among the strongest in the nation. Landlords cannot increase rent, decrease services, or file for eviction within 180 days of a tenant exercising their habitability rights, including making a repair request, filing a code enforcement complaint, or withholding rent due to habitability defects. Any adverse action during that window creates a rebuttable presumption of retaliation, and if the tenant prevails, the landlord can be liable for actual damages plus punitive damages of up to $2,000 per violation. For the complete guide to California habitability laws, visit tenantscreeningbackgroundcheck.com and subscribe to our channel. In California, staying compliant isn't optional, it's survival.